halted. The organizational structure of SARS that provided oversight was pulled apart. Dissent was stamped out by instilling distrust and fear. Accountability to other state authorities was defied, and capacity for investigating corruption was disabled. And then finally, instead of fostering a climate and a culture of healthy dissent, the Nugent Commission found that Mr. Moyane engendered a culture of fear and intimidation, and there was a purging of competent officials. Now, Chair, I have no doubt that this Commission has no desire to repeat the work of the Nugent Commission, nor does this Commission seek to re-enter the fray on the same basis. In the absence of any judicial review of the Nugent Commission's report, those findings, of course, stand, and no evidence in contradiction of any such finding we would submit should be admitted. While the remit of that report was wide, there are certain issues which were not investigated by Judge Nugent and which are now the focus of this Commission's work in relation to SARS. And matters concerning SARS which were not within the remit of the Nugent Commission's work, or in respect of which evidence was not led and which are relevant to this Commission's inquiry, will properly form the subject matter of testimony this week. And so, Chair, the focus will be on the consulting company BAIN's actions in connection with SARS, and Chair will recall that the Nugent Commission concluded that BAIN had not told the full story. Secondly, there will be an emphasis on Mr. Moyane's role in SARS, and it will be recollected that Mr. Moyane did not give evidence before the Nugent Commission. And then thirdly, evidence of the impact of the capture of SARS upon the institution. And so, Chair, whilst the Nugent report makes detailed findings as to the institutional dismantling of SARS, this Commission's mandate requires that the strategic significance of this capture of SARS be contextualized within the big picture of the state capture inquiry. If I could briefly then just highlight for the Commission the patterns and processes of state capture and where the evidence that will be led fits in. The Nugent Commission's findings and the evidence led showed that the repurposing of SARS followed familiar patterns and processes of state capture that have been observed in other state institutions. And SARS offers, we would submit, one of the clearest demonstrations of this pattern of repurposing observed in other state-owned entities and state institutions. And this includes, so the evidence will show, the collusion between SARS, the executive, and BAIN with a planned and coordinated agenda in relation to SARS well in advance of either BAIN or Mr. Moyane's appointment. Secondly, the purging of competent top officials and the climate of fear. Thirdly, the strategic positioning of compliant individuals. And fourthly, the restructuring and deliberate weakening of institutional functions. And all of those are common features which this Commission has heard in relation to other institutions. In addition, we will contend that the evidence to be led bears out the pattern of procurement irregularities which have so far loomed large in the evidence heard by this Commission, and that would include the collusion in the award of a contract, the irregular use of confinement and condonation to avoid open competition, transparency and scrutiny, and thirdly, the use of consultants to justify changes that were really only necessary to repurpose SARS. Chair, the witnesses that will be heard this week are as follows. Firstly, today, the Commission will hear from Mr. Atholl Williams, who is a former Bain & Company employee. Secondly, tomorrow we will hear from Mr. Vlok Symington, who is a senior employee of SARS. Thirdly, Mr. Johan van Locherenberg, who is a former SARS employee. And then finally, on the 25th, from Mr. Tom Moyane, the former Commissioner of SARS. And then, Chair, an arrangement has also been made that Mr. Moyane will conclude his cross-examination of Minister Gordhan in an evening session which has been set for today, the 23rd of March. If I may then briefly take the Commission to the essence of the evidence that will be led. In relation to Mr. Atholl Williams, as I have indicated, he was a BAIN Company employee. He was employed in various roles. The ones we are interested in for purposes of the Commission today are, firstly, that he was engaged as an independent consultant from September of 2018 to December 2018 to oversee an investigation that had been commissioned by BAIN into the award of the contract with SARS and the work which it did at SARS. Then from January of 2019 until May of 2019, he was employed as an independent advisor to develop a so-called remedy plan for BAIN. Then thirdly, from May of 2019 to August 2019, he was employed on a part-time basis as a partner serving on the BAIN Africa Oversight Board. And then fourthly, he resigned at the end of August of 2019 because he was of the view that BAIN had not been transparent with him and the South African authorities regarding their investigation into what happened at SARS under their tenure. And he made various media statements in 2019 that BAIN was withholding information about the restructuring at SARS and their work at SARS. Mr. Williams was approached by this commission for an interview which was held. Pursuant to that, a summons was issued against him to produce books and documents, which he did, and subsequently he furnished the commission with an affidavit dated the 23rd of July 2020 and annexes thereto, and that will form the basis of the testimony that is to be produced today. Chair, you are aware that BAIN launched an application which is to be found in file SEQ 44/2020. In it, they applied for leave to cross-examine Mr. Williams, leave to make oral and written submissions to the Commission, and then also an order that confidentiality...
Just 1 second, Mr. Franklin. Yes, you may continue.
Thank you. Chair, the application asked for various relief, as I have said, and the third prayer was that confidentiality be maintained over certain portions of Mr. Williams's affidavit and its annexures, and for those to be withheld from public disclosure. I'm happy to say, Chair, that in discussions with my learned friend, Mr. Cockrell, we have managed to narrow the ambit of that application considerably. You will have seen that there was an Annexure X which was updated, and that had various categories, and in relation to each of those categories, BAIN had originally asked that the evidence be kept confidential. In relation to the first of those sections, so-called sensitive personal information regarding whistleblowers, it's been agreed that the personal details of two persons who are referred to in the affidavit will be redacted and not referred to. In relation to the other two people, Mr. Williams will say that he has been given specific permission by those people to reveal their identities. So that has been dealt with. In relation to the category of so-called legally privileged materials and information included in the affidavit, there was a relatively long list. I understand that BAIN will persist and place on record that they still regard certain of the information to be led as privileged and confidential, but they do not seek any relief in relation thereto, and Mr. Cockrell will no doubt outline that for the Commission. Then in relation to the so-called commercially confidential information, that too falls within the same ambit of the agreement, i.e., although it is maintained that it is commercially sensitive, and no relief will be sought in relation to that. And the final category was investigations by foreign regulatory and other bodies, referred to in Mr. Williams's affidavit. And the approach of the Commission is that there is no reason not to refer to those investigations. I understand that BAIN will contend that they ought not to be referred to, but there is no specific relief that is sought in relation thereto. And then that really deals with the application in its totality, and the Chair has indicated to BAIN via the Secretariat that the application for leave to cross-examine and to make oral and written submissions will be dealt with in due course on a date to be arranged by the Commission. The sole remaining issue then regarding BAIN and what it requires is a request which was directed to the Commission in a letter dated the 26th of November 2020, in which it seeks permission from the Commission that affidavits which set out its version of events concerning its role at SARS be publicized by some or other means at the same time as Mr. Williams's testimony is uploaded onto the Commission's website. I understand Mr. Cockrell will motivate that particular request. The approach of the legal team is that there is no basis to accede to that request. So that is the position in relation to Mr. Williams and the BAIN application. There have been various other responses to Mr. Williams's affidavit. There have been letters which have been received, as well as affidavits which have been filed, and applications to cross-examine. I need not go through all of those. They are collected together in one of the SARS bundles, and the representatives of certain of those persons have placed themselves on record. Proceeding then to the second of the witnesses who will give evidence this week, that is Mr. Vlok Symington. He is currently an employee of SARS and a senior legal advisor. He is represented, and tomorrow the representatives will place themselves on record. He was asked by the Commission to submit himself to an interview in connection with an incident which has been described as a hostage incident that occurred at the SARS offices in October of 2018. And he ultimately provided the Commission with an affidavit dated the 2nd of November 2020, which will be the subject matter and focus of his testimony. And consequent upon that, various other people also gave affidavits, which are also bundled in the SARS bundle. Similarly, such applications as there are to cross-examine, as well as Mr. Symington's own application to cross-examine various people, will be, as I understand it, dealt with by the Chair on a date set by the Commission. The third witness is Mr. Johan van Lochenberg, who, as I've said, is a former SARS employee. He was also approached by the Commission regarding the Commission's investigation into compliance units at SARS and the fate of those units and how they have been affected by the restructuring which took place under BAIN and Mr. Moyane. And he provided the Commission with an affidavit dated the 11th of November of 2020, which will be the subject of the testimony that he will present. There have been various applications which have been served in relation to Mr. van Lochenberg's testimony. We are in the process of attempting to resolve those if we can. If not, then the Chair will be asked to hear and determine those applications. Chair, apart from that, there are bundles which have been prepared and which are before the Commission. Returning then to the proceedings for today, I understand that the Commission would first like to hear BAIN's requests, and that will be done via Mr. Cockrell. Thereafter, I will lead the evidence of Mr. Williams, and following that, in the evening session, the cross-examination of Minister Gordhan by Mr. Moyane's representatives will take place. So, against that background, Chair, may I ask that we deal with the residual BAIN issues and invite Mr. Cockrell to make his submissions.
Thank you, Mr. Franklin. Mr. Cockrell, are you ready to address me on BAIN?
Yes, thank you, Chair.
Yes, you may go ahead.
Sorry, Chair, I heard you say, invite me to address you, and then I'm afraid it went dead on my side. I couldn't hear what you were inviting me to address you on. I apologize.
Oh, no, on the BAIN application. That's what I said.
Thank you. Thank you, Chair. Chair, I won't have to detain you for very long. I'm very grateful to my learned friend, Mr. Franklin, for that very fair summary of where we are. I need to address you on two issues. I need to bring you up to speed with where we are on the confidentiality application. And then I need to address you very briefly on the application by BAIN in order to publish its own affidavits. May I address those in turn? Chair, you'll know the application by BAIN and Company had a number of prayers in the relief. Prayer 4 sought relief in relation to confidentiality. As my learned friend, Mr. Franklin, pointed out, there was an annexure to the notice of motion, Chair. It was a long annexure, Annexure X. We, BAIN, reduced that annexure in the course of last week. And in the course of Friday, we've reduced it even further, Chair. So what has happened is there's no longer any point of contestation between us and the Commission regarding the various categories of documents. And Chair, I need to make it clear, the reason why BAIN and Company has effectively decided not to persist with that application is it's very conscious of the fact that this Commission is working under time pressure, and it wants this Commission not to feel that it is being obstructionist or trying to obstruct the working of the Commission. And so where BAIN and Company comes out is this, Chair. If you were to go to Annexure X in the amended version, I'll go through those categories very briefly. It's largely in alignment with what my learned friend Mr. Franklin said. Annexure X really had 4 categories. The first category was sensitive personal information included in Mr. Williams's affidavit. And the view taken by BAIN is that because those 4 people hadn't given consent for their identity to be disclosed, their identity was therefore confidential. We are now told by the evidence leader that Mr. Williams has permission from 2 of them. And so the agreement we've reached with the evidence leader, Chair, is that the identity of the remaining 2 will be anonymized. But there's agreement between us in that regard, Chair. We don't seek a reading from you. Chair, the second of those categories, the privileged information, Chair, I need to place this on record. You'll know that Mr. Williams came into possession of various documents in the course of his employment by BAIN and Company, and the view taken by BAIN and Company is that some of those documents are privileged. Chair, I see my screen is frozen. Are you still there?
We can still see you. We can hear you.
Thank you. Thank you, Chair. Chair, those documents in some cases came from the external legal advisors to BAIN and Company, Baker and McKenzie. In other cases, they came from the in-house advisors to BAIN and Company. In many cases, those documents are called privileged. They are labeled privileged. The view taken by BAIN and Company is that those documents are privileged and remain privileged. But Chair, for the reasons I've given earlier, BAIN no longer seeks any ruling from you regarding the confidentiality of those documents. Chair, I say again, BAIN and Company doesn't wish to hold up the workings of this commission, and so it has agreed not to persist with that application. In short, we assert privilege over those documents, but Chair, we no longer seek a ruling from you in relation to the second category, legally privileged documents. Chair, the third category, commercially confidential information, again, BAIN and Company has decided not to persist with that application. We no longer seek any ruling from you regarding the confidentiality of those documents. And Chair, then finally, the fourth category, investigations by foreign regulatory and other bodies. Chair, those are allegations in Mr. Williams' affidavit, which refers to interaction between BAIN and Company and regulators in other jurisdictions. The view that BAIN and Company took is because those regulators regarded the interactions as being confidential, it was not within the power of BAIN to waive confidentiality. And so we had a discussion with the evidence leader last week, and we ascertained whether the evidence leader was comfortable eliciting the fact of those interactions. And the view taken by the evidence leader is that the Commission had no difficulty in that regard. So, Chair, the position of BAIN and Company is it regards those interactions as being confidential, but it no longer asks for any relief from you, Chair. In other words, if the evidence leader has no difficulty eliciting that information, BAIN and Company doesn't seek any ruling from you regarding confidentiality in that regard. And so, Chair, where all of that goes is we're in the, may I say it, happy position where no ruling is sought from you in relation to any of the confidentiality portions of the BAIN and Company application, Chair. There's agreement between ourselves and our learned friends, Mr. Franklin, as to how the evidence will be led, and we don't seek any ruling from you. I've simply placed on record what the position of BAIN and Company is. Chair, that then brings us to the second part of what I have to address you on, and here, unfortunately, we do seek a ruling from you. Chair, you won't find this in the BAIN and Company application. This is, in fact, something that was contained in the letter written by BAIN and Company to the Commission on the 26th of November 2020. And Chair, the position is this. BAIN and Company has submitted two affidavits to you.
I'm sorry. Mr. Franklin, do you have a copy of that letter? The letter of November 2020 that Mr. Cockrell is referring to?
Yes, Chair.
Or is it in the bundle here?
Yes, I will endeavour to locate that for you.
Okay, all right.
Bring it to your attention.
Okay. Yes, you may continue.
Yes, apologies, Chair. I can't refer you to the bundle because I don't have it, but I'm going to summarise the letter as fairly as I can, and I'm sure my learned friend, Mr. Franklin, will make it available to you in due. Chair, the position is this. Mr. Williams filed his affidavit, his witness statement. When BAIN and Company applied to you for various forms of relief, BAIN and Company put up two affidavits, one from Mr. Min and one from Mr. Moolman. And the difficulty that BAIN and Company now finds itself is this. It is simply not sure whether it's in a position to publish those two affidavits once Mr. Williams commences his evidence. And Chair, that is the basis of the relief we seek from you today. What BAIN and Company is asking for is permission from you that BAIN and Company, can publish those affidavits. My learned friend, Mr. Franklin, with respect, misunderstood it. He seemed to think that we were asking you for an instruction that the Commission must publish the Bain and Company affidavits. But that's no part of our relief, Chair. We don't ask the Commission to do anything. All that we ask for is permission that Bain and Company, should it decide to do so, can publish its own affidavits in any form it considers appropriate. And Chair, the reason why we ask that relief from you is if one goes to regulation 11.3b, Chair, not the rules of this commission, these are the regulations. Regulation 11.3b is drafted in with respect to a slightly obscure form. This is what it says. It says, no person shall, without the written permission of the chairperson, and then A says, disseminate any documents submitted to the commission by any person in connection with the inquiry, or publish the contents or any portion of the contents of such document. So, Chair, what the regulation is saying is no person shall, without your written permission, disseminate any documents submitted to the commission or publish the contents of any such document. And Chair, may I say a contravention of that provision is a criminal offence in terms of Regulation 12. Now, Chair,
I'm sorry, what regulation is it again?
Chair?
What regulation is it again?
Chair, it's Regulation 11.
11.
Regulation 11, sub E, sub A.
Oh, okay, okay.
So, Chair, when one reads that regulation, it's not immediately obvious whether it prohibits BAIN from publishing its own affidavit. It's the BAIN affidavit, but BAIN submitted it to this commission. On one reading, what the regulation is saying is that BAIN is prohibited from disseminating that document, its own affidavit, because it has published it to the commission. But Chair, even if that is not the correct reading of that regulation, the difficulty BAIN would still find itself in is the BAIN affidavits are, of course, referring to Mr. Williams' affidavits, which were also submitted to this commission. So even if Regulation 11.3a doesn't prohibit BAIN from publishing its own affidavits, it would still have that effect in as much as the BAIN affidavit is cross-referring to Mr. Williams' affidavit. And so, Chair, that is the purpose of today's application. The view taken by BAIN.
Mr. Cockrell, let's just try and see if we understand what paragraph A says. There are two possible interpretations, it seems to me. There is no doubt that the prohibition relates to any document submitted to the Commission. So BAIN's affidavit, once it has been submitted to the Commission, would fall under that. And then it says document by any person in connection with the inquiry. I suspect what you are saying is that the reference to any person is not a reference to a document of the person who seeks to disseminate the document. I suspect that's what you say. So yes, that might be one possible interpretation. Another one might be that the prohibition is intended to make sure that any document that has been submitted to the Commission, even your own document, you may not publish without the written permission of the chairperson. Now, on the face of it, the interests that would be sought to be protected by that prohibition are the interests of the investigation of the Commission. So if that is correct, then there may be difficulty in the interpretation that would say, I am free to publish my own affidavit that I've submitted to the Commission, and I'm free to do so without the written permission of the Commission. Because the mischief that is sought to be avoided would be the same whether I'm publishing or disseminating my own affidavit or disseminating somebody else's affidavit. I think that might be the difficulty with that interpretation. Whereas if we adopt the interpretation that the reference to any person includes the deponent to that affidavit or the author of that document, then that interpretation seeks to make sure that any document that has been submitted to the Commission is now part of the Commission's investigation. And to protect the investigation of the Commission, nobody should disseminate that document without getting the written permission of the Commission. I would be inclined towards that interpretation rather than the one that says as long as it is your affidavit, you can publish it even if you have submitted it to the Commission. But you might have something different to advance, or you might say whatever the correct interpretation is, this is what you would like to say.
Yeah. Chair, with respect, from our perspective, it doesn't matter which interpretation is correct. May I say, with respect, you're entirely correct, Chair. Regulation 11.3a could be read as prohibiting the author of the document from publishing his or her own document, or it could be read as only referring to a third person. But Chair, from Bain and Company's perspective, it really doesn't matter, because Bain and Company has written to you seeking your permission, so that no matter...
Okay, so we quickly dip out of those proceedings at the State Capture Commission of Inquiry to take you to the Durban